I thank the member for Orange. We're considering Judicial Officers Amendment Bill. The question is the bill now be read a second time. I call the member for Baulkham Hills.
Thank you, Mr Acting Speaker. I appreciate the opportunity to speak on the matter of the Judicial Officers Amendment Bill 2012, and would like to open my remarks by highlighting the comments made by the member for Fairfield, who described his opposition to this particular bill because it was repugnant to the principles of constitutional monarchy. Now that, as you would know, Mr Acting Speaker, is quite ironic, since he represents a political party that is opposed to the constitutional monarchy, and indeed on the 6th of November 1999 fought unsuccessfully to have the constitutional monarchy removed from Australia's arrangements. So I'm delighted to now see, 13 years later, the member for Fairfield, and one assumes other members of the Labor Party have re-engaged their commitment to constitutional monarchy and now realise that it is indeed the most efficient form of government, particularly for the people of New South Wales. Mr Acting Speaker, can I, in making opening remarks, also highlight the three things that make Australia a great nation? The three things that are unique to Australia and Australians, and the three things that I believe underpin the need for us to ensure all legislation relating to judicial officers is transparent and fair. That, of course, is the fact that Australia is built on sacrifice. The members of the first AIF in Gallipoli taught us that. They taught us that you should go the extra mile for your fellow human being, that you should make personal sacrifice if it indeed means you will provide comfort and understanding to somebody other than yourself. Our sense of volunteerism is unique and indeed makes us a civilised society. Volunteerism is the cornerstone of Australiana and indeed makes the SES, the RFS, St John Ambulance and the other volunteer combat agencies, the organisations that are certainly renowned around the world and indeed the envy of the world. But finally, Mr Acting Speaker, what makes our judicial system important is our commitment to fair play, our commitment to transparency and our commitment to making sure that, as the member for Fairfield said, the constitutional arrangements in our system ensures that everybody can come to the court with confidence. So having said that, I think that all members, even those from the opposite side, acknowledge that public confidence in our court system is indeed the utmost importance. Those with matters before a court or tribunal in New South Wales need to have certainty that their matter will be dealt with appropriately and in a just manner. Public confidence in our justice system is in part dependent upon the quality of judicial office holders in this state. The people of New South Wales expect that not only the most competent and able individuals are elevated into the judiciary, but they're encouraged. Judges and magistrates hold a privileged place within the community and as such are burdened with tremendous responsibilities and authority. The independence of the judiciary is important and essential for the application of the rule of law. Further, the separation of powers between the legislature, executive and judiciary is crucial to the maintenance of good public administration in this state. As such, the Judicial Commission has an important role to play in the administration of justice in New South Wales. As an independent body, the Commission is tasked with receiving and investigating complaints about members of the judiciary. The Commission's Conduct Division is further tasked with referring instances of judicial conduct that it believes could require parliamentary consideration of the removal of the judicial officer from office. The Judicial Commission ensures that judicial office holders are held to account and removed if necessary, while also maintaining the independence of the judiciary. This amendment merely ensures that the Attorney-General is informed of matters before the Commission as is appropriate, being the first law officer of this state. The information to be provided to the Attorney-General will be limited and in no way infringes upon the independence of the Judicial Commission. The Attorney-General should be informed of serious matters before the Conduct Division of the Judicial Commission, being the responsible minister. This will not mean that the Attorney-General will be giving a running commentary, but rather merely informed that proceedings are being undertaken. The current scenario is actually quite unacceptable. Given the media can be informed by either court reporters or complainants, at present the Attorney-General is unable to advise regarding these matters, given that he or she is unable to obtain relevant information from the Commission. The amendment will streamline the process of dealing with complaints regarding judicial office holders. After all, the ultimate decision about whether judicial office is terminated falls on this Parliament. As such, it is only appropriate that the responsible minister will be acquainted with the matter before presenting the Commission's recommendations for parliamentary consideration. For these reasons, Mr Acting Speaker, I commend the bill to the House.
I thank the member for Baulkham Hills.